Welcome to the Journal Editorial Report. I'm Paul Gigot. President Trump was impeached by the House of Representatives for the second time on Wednesday, just days before he is set to leave office. The timing of a trial in the Senate remains unclear, but any action is now sure to take place after President-elect Joe Biden is sworn in on Wednesday, raising questions about the constitutionality of a post-presidential impeachment. Joining me now is Michael Mukasey. He served as the 81st Attorney General of the United States. Judge Mukasey, great to see you here in the new year. So let me ask you first about the president's behavior for which he was impeached. Do you think it was an impeachable offense?
Well, you say the president's behavior for which he was impeached. I think the president's behavior constituted an impeachable offense, including all the misrepresentations of law and fact that he made about the election, about how the defects in the election that he says could have changed the outcome, about the power of Congress to act after the electors had been chosen by the states, about the power of the vice president to affect the outcome, that he then told people to go to the Capitol and be strong, notwithstanding that he said that they should go peacefully and patriotically. But once the violence started, he could have anticipated violence, and once the violence started, he took no steps to stop it. He was aware of it, he was watching it from within the White House, and didn't issue any statements, certainly didn't go out there and try to stop it. So for all of those reasons, I think what he did was impeachable.
Okay.
Now, that wasn't what he was charged with.
Well, let me ask you specifically about one element of that, which is the charge of incitement here to
Yes.
violence. And now, you know, we had an op-ed this week by a prosecutor who said it would not have constituted incitement under the criminal law. What about politically?
I don't know that there's any difference between the criminal law and politically. If you're talking about incitement, that has to do with whipping people up at the time. And his statement that they should go peacefully and patriotically is sufficiently ambiguous that maybe to get him off the hook. Again, understand, this is committed to the political branches. This is something the Senate will deal with. No court will ever deal with it. So it's a question of how many votes support the ayes and the nays.
Well, but I assume a prosecutor under the Biden presidency could try to bring a charge, I guess. Could they not? I mean, he can't be charged after he's in office criminally.
He after he's left office?
Yeah, after he's left office. Yeah. That's what I mean. Yeah.
Right.
Okay.
Right.
Okay.
He can be charged criminally. In fact, the impeachment clause says specifically that he's not. There's nothing to prevent charging somebody criminally later on.
Okay, so the trial in the Senate, if there is one, will take place after the president has left office. What do you think of the constitutionality of that?
Obviously, there are two sides to that. Some people argue that if he's no longer the president, he can no longer be impeached. Some of them point to the fact that the impeachment clause speaks of the Chief Justice presiding over a trial of the president. If he's the ex-president, then you don't have a trial. I understand some of those arguments. I think the better view is that he can be tried. There's some precedent for having done it as to, I believe, a cabinet officer back in the 1870s. But more to the point, at the time the impeachment clause was put into the Constitution, the people who drafted it were very well aware of a case involving the Governor General of Bengal, who was impeached by Parliament and convicted, notwithstanding that all of that happened after he left office. So if you're talking about the intent of the framers, it was clear that they knew that you could impeach somebody and try him after he leaves office.
Okay, let's assume there is, in fact, a trial, and the president and his lawyers sue to say it's unconstitutional, and that goes to the courts. Do you think that the courts would rule on that, or would they say that this is really a political question to be left to the Congress and to the Senate and the political branches?
Oh, I think clearly it's a political question that's to be left to the political branches. This is not something the courts involve themselves in.
So you just think they'd say it's a non-justiciable issue?
Correct.
Yeah. Okay. All right.
That's my prediction. Again, we don't have it's not that we've got a detailed roadmap for this. It hasn't happened before.
It hasn't happened before, I know. Separate from the legality of all of this, what do you think of the wisdom of impeaching a president, going to trial and convicting a president after he has left office? And this could be weeks or months from now, depending on when the Democrats decide to move.
It could indeed, and I have to warn your viewers that the offices that I've held before don't qualify me any more than they qualify anybody else to answer that question. There is something to be said for accountability. On the other hand, the charge that was brought of inciting insurrection, again, isn't really the impeachable offense that's involved here, if you will. I think that there's a long course of behavior that is more significant, but that was not the specific charge that was brought.
Are you troubled at all by the potential precedent of convicting a president after he leaves office? I mean, we could have done that to Richard Nixon, for example, and nobody decided to do that. Yes,
and he negotiated a pardon for himself to avoid that. I think if we're talking about cases repeating themselves, we got a lot more to worry about than whether this is precedent. There's one thing that does concern me more than this as precedent, and that is the language that they used in the article of impeachment, referring to an insurrection. That word is to be found in the 14th Amendment, which not a lot of people have paid attention to, but it can be used as the basis for barring somebody from the Senate, from the House of Representatives, if they have done anything to support an insurrection. And that word was chosen, I think, purposely. In fact, James Clyburn referred as late as this morning in an interview on the Cavuto program to going the 14th Amendment route. Now, the 14th Amendment can't be used against the president, but it can against members of the Senate and the House if they're found to have participated. And there are people who are suggesting that somehow people in the House took citizens on tours the day before so that they could case the place and figure out how to penetrate. And if they choose to press that means the president is only the beginning.
All right, but of course they have to find evidence and name individuals for that. All right, thank you, Judge Mukasey. Appreciate your coming in.
Of course.